So there's an update in the Texas Anti-Trans Services for Children. This was the one where Greg Abbott and Ken Paxton had issued a directive in the form of a letter directing the Texas Department of Family and Protective Services to investigate and treat all situations where doctors or caregivers or parents had provided gender-affirming care for children under the age of 18, that they were to treat this as child abuse. And what had already happened was one parent who worked for DFPS had already been suspended from their job pending their investigation as child abusers for providing gender-affirming care, I think it was puberty blockers, at the direction of both a medical doctor and a psychiatrist for their child who had had gender dysphoria issues for a long period of time. And I emphasize this because one of the arguments in favor of Ken Paxton and Greg Abbott's directive was that these things are being done without any care or caution, permanently altering or even surgically altering children, which is not what's happening. In all the research I've done, I have not been able to find any evidence where people are taking this lightly. So in order to overcome the court's initial order with a temporary restraining order, Ken Paxton had filed an appeal, and that appeal was denied because it was only a temporary restraining order. And then when the court issued a preliminary injunction, which is more permanent, it's for the duration of the litigation, as opposed to just for a week or 2 weeks in the form of a temporary restraining order, Ken Paxton again appealed to the Texas Court of Appeals, 3rd District at Austin, and now that appeal has also been denied. In that appeal, Ken Paxton had asserted that the rules of appellate procedure in Texas already stayed the preliminary injunction, so the appeal has the function of reinstating Greg Abbott and Ken Paxton's directive, the one calling gender-affirming care for children child abuse. That now has been overturned back in the other direction, and the preliminary injunction in favor of the Mary Doe plaintiffs is now back in place. The court writes, before the court is a pre-submission challenge to a district court's order enjoining the Department of Family and Protective Services and its commissioner from complying with the terms of a letter issued by Governor Greg Abbott on February 22nd. That letter requires the department to conduct a prompt and thorough investigation of any reported instances of gender transitioning procedures being performed on minors and classifies the use of those procedures as child abuse. The letter further requires the department to coordinate with other agencies in pursuing criminal penalties against any parent allowing such procedures and against any professional or member of the general public that suspects but fails to report this purported abuse to appropriate authorities. Following an evidentiary hearing, the district court temporarily enjoined appellants from abiding by the directives within the letter pending the outcome of this litigation. That injunction is currently suspended pending the resolution of this appeal. Appellees now seek emergency relief pursuant to Rule of Appellate Procedure 29.3, asking this court to reinstate the temporary injunction for the duration of this appeal. Appellants oppose the motion, arguing that the rule does not afford this court with discretion to award the relief requested. As we observed, Rule 29.3 gives us great flexibility in preserving the status quo based on the unique facts and circumstances presented. The status quo is the last actual, peaceful, non-contested status which preceded the pending controversy. In addition, Rule 29.3 provides a mechanism by which we may prevent irreparable harm to parties properly before us pursuant to our appellate jurisdiction in an interlocutory or during litigation appeal. One of the orders we may issue under Rule 29.3 to maintain the status quo and prevent irreparable harm is an order reinstating a suspended injunction. A litigant's request for injunctive relief is predicated upon that party's assertion that irreparable harm will result from the challenged act or action. To obtain a temporary injunction, the applicant must plead and prove 3 elements. 1, a cause of action against the defendant. 2, a probable right to the relief sought. and 3, a probable, imminent, and irreparable injury in the interim. In this case, the trial court reviewed the evidence and concluded that the appellees had established a probable right to recovery on their claims. It further concluded that the appellees have made a sufficient showing that allows appellants to follow the governor's directive pending the outcome of this litigation, and that would result in irreparable harm. Having reviewed the record, we conclude that reinstating the temporary injunction is necessary to maintain the status quo and preserve the rights of all parties. Therefore, without regard to the merits of the issues on appeal, which are not yet briefed to this court, we exercise our discretion under Rule 29.3 to reinstate the injunction as issued by the district court on March 11th. It is so ordered March 21st. So that means that while the appeal is being heard, the appeal of the district court's preliminary injunction, that preliminary injunction will remain in place, and it is not stayed pending the appeal. So that's good. That means that DFPS, Ken Paxton, and Governor Abbott don't get their way, don't get to call children who are experiencing gender dysphoria issues and seek treatment for those issues, even basic treatment that is appropriate under medical directives and medical understanding, that cannot be treated as child abuse, which I've made my opinions known before and certainly suffered backlash from some small subset of the population that doesn't seem to understand these issues and doesn't seem to want to watch the video and doesn't seem to want to cite sources, at least not credible sources. So stopping short of editorializing further, that's the status of that. Yay. There's still a long way to go in getting rid of that Putin levels of stupid directive. That's all I have to say about that. Let me know what you think in the comments below. I'll probably have to hold comments again, and so I apologize if your comment gets filtered out. I can't get to all of them sometimes. But thank you for participating, and I really do appreciate you watching the video. Thanks for watching! Special thanks to my top supporters in April: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Gutbrodj, ShadowTycho, Earthbound Star, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt, Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.